Hi, Carter. How are you?
I'm good. How are you?
I'm fine, thank you. Very nice to see you. I know we've been working recently. We had a Supreme Court case intervention in Bharwani, and we were working our team together on this case. And I'm happy to have you today as my guest because we will be talking about, surprise, surprise, interventions and maybe clarify a bit what interventions are. And you're the perfect guest to talk to about this because you've had quite a few cases and some experience in this area. So, um, before we start talking about interventions, maybe I'll just give you the opportunity to introduce yourself to our viewers, and then we'll start talking about our subject.
Sure. I'm a criminal defense lawyer. I do mostly appeal work. Most of my work is at the Court of Appeal, but I spend a little time at the Superior Court, and sometimes I also act as intervening counsel at the Supreme Court.
Well, thank you for that, Carter. And let's start with on the topic of interventions. What is the difference between an intervention and the argument that is brought by the parties before a court?
So when you're representing one of the parties before the court, the arguments you made are driven by the result that you want to achieve for your client. And so you're going to argue the interpretation of the law that best favors the outcome that you hope to achieve for your client. Whereas when you're acting as intervener counsel, you don't take a position on the facts or the law or the outcome of the particular case. So you get to take a little bit of a broader view of the legal issue that the court's deciding and how it's going to have application, not just in this case, but in other cases going forward. And the position you take is going to be informed by the interests that the organization you represent is interested in. But still, there's a broader range of positions that you can take as intervener counsel.
Okay, but then who can be an intervener?
So any person or organization with an interest in the outcome of the issues that the court is going to decide, who has something to contribute to the court that is going to be useful to the court as it decides the issues in the appeal, and that is different from what the other interveners and the parties are going to argue in some way, either because your organization brings a different perspective or a somewhat different argument on what the law should be.
All right, but then let's say you decide that you do have an interest and you do want to intervene. How do you actually become an intervener in a case?
So you have to first you have to apply for leave to intervene, and so you will
Always, right? You always have to apply for
always, yeah,
it.
even if you're acting for an organization that regularly intervenes, you always have to make an application in every case, and you have to show the court, why the interests represented by your organization are going to be impacted by the appeal and give a sort of overview of the the legal issues raised by the parties that you're going to be making submissions on and what your position is going to be on those issues. And often, you'll file an affidavit from somebody in the organization that you represent, explaining their history of intervening in previous cases, in order to show the court that you're going to be able to provide them with some real assistance as they decide the issues before them.
All right. Now, one of the challenging part of doing intervention work is how to distinguish the intervener's argument from the main argument that is going to be argued before the court. Can you tell us a bit more about that, Carter?
Right. That's always really important because the court doesn't want to hear from a whole bunch of lawyers making the exact same arguments to them for the exact same
Yeah.
reason. It's not very helpful to them. So you definitely want to find out kind of at the outset what arguments the appellant, usually the appellant and the Crown are going to be making, and you want to find out who else is interested in interested in intervening and kind of discuss with them what arguments they're going to make so that you can kind of get a sense of what arguments are going to be before the court and how, how can we distinguish ourselves a little bit.
All right, but I mean, and there are cases, and in criminal law, we routinely have interveners appearing in criminal cases, but there are some cases where there are multiple interveners and sometimes way too many. I remember the Chouhan case, there were a lot of interveners. So in a case like that, where you have not just one or two interveners, but you have really a massive number of interveners, how do they work? How do they like, do they work together, or is each one of them focusing on their interests and what they want to bring to the court argument? How does it work in those types of situations?
Right. That's a good example, actually, because I worked as intervention counsel on Chouhan along with everybody else.
Yeah.
Yeah, Jill Presser and I represented the Advocate Society in that appeal. That was the case that dealt with the amendments um, to the jury rules, abolished peremptory challenges, and made other changes.
There were a lot of
There
interveners
were
in
a
that.
lot of interveners. Yeah, a lot of different groups intervened. And that was definitely a case where very early on we were in communication with the other interveners and kind of figuring out what arguments they were going to make and thinking about what we could do that was going to be different. And as we got ready to file our motions for intervention, we also most of us circulated kind of working drafts, like just to give people a sense of this is the argument that we're going to make, so that we can make sure that we've kind of divided the field up in a way that we weren't replicating one another's arguments.
But I mean, there are situations where you have a group that has an organization or an association. They really want to be part of they really do want to intervene in a case. They want to be part of the argument that's happening in court, but maybe their arguments are very similar to those of other interveners. So what do they do in this case? I mean, do they just let other groups take on and make the arguments for them? Or if they really want to be heard, because I think it gives groups as well the opportunity to have a voice in court, for their voices to be heard. So in that case where their argument may not be very distinguishable from other interveners or the main argument, but they really do want to appear, what can they do in this case?
Well, I think in that scenario, like often, the difference lies in they might be making the same argument, but the difference is in kind of the reason why they're making that argument and the particular perspective of their organization. So, for instance, when I act as intervention counsel with the Empowerment Council, as we did recently in Bharwani, um, our perspective is our clients who have mental health issues, and we might be making very similar arguments to some of the other interveners, but we're making the argument for the particular perspective of this is how this issue impacts our clients in particular, and we want to make sure you consider their interests when you interpret the law.
All right. And speaking of clients, Carter, can you just tell us a bit more about the relationship with the client in the context of an intervention?
Yeah, so that's another thing that's a little bit different from when you represent a party. The relationship with the client is a little bit different from the relationship that you would have with an accused person who's appealing their conviction or their conviction and sentence. It's a much more collaborative process, and the client in an intervention is going to be much more involved in kind of the finer issues of the legal arguments to a greater or lesser extent, depending on who the organization is and who the instructing individual is. But generally speaking, if I'm representing somebody at the Court of Appeal, an accused person, we'll have a discussion about their goals for the appeal, and maybe they'll have some thoughts on what issues I might look into. They might have their own thoughts about what was not fair about their trial. And I'll go and look into everything and I'll come back to them and I'll say, here are the issues that I see. And this is, these are the things that I think we might have some success in advancing. And I'll kind of go forward on that basis. Whereas if I'm acting as intervenor counsel, we'll have a discussion about why the issues are important to the client and what kinds of arguments I might make. And then I'll go and I'll do some research and I'll do some thinking, and then I'll come back to the client and say, this is how I propose to argue it. Like, is that what you imagined? And I'll, solicit some direct feedback from them. And then, similarly, when I'm getting ready for oral argument, I would go back to them and we would have a discussion about, how I'm going to use my 5 minutes to make oral submissions, like what are the most important issues from the perspective of the client. And of course, I'll advise them about what other counsel are going to be focusing on their oral arguments. And so, how we can advance our interests, but also kind of distinguish ourselves from the others. And so, they'll give me some feedback on that. And so it's more of a collaborative process.
And okay, because you did mention the time, and that's actually an important point. The times are different. The time that the intervener has to make their arguments is not the same as the party. So maybe we can talk also a little bit about that. And it's actually quite a challenge. I mean, from working on Bharwani, I mean, you have very limited time, and you have to make your point in that limited time that is given to you. So if you can talk maybe a bit about that, Carter.
Yeah, I mean, it's almost like a totally different kind of advocacy,
Yeah.
it's so difficult to do anything at all in 5 minutes. And so I think sometimes even for very experienced advocates, it's difficult to do it really well. And I see people doing it in different ways. Sometimes people are sort of like barreling full speed ahead, like I'm going to use every inch of my 5 minutes. And some people, take an approach of kind of paring it down and, focusing on just making one or two points really clearly. Yeah, I think that sometimes, people are so kind of focused on I'm going to say as much as possible, or I'm going to get through what I have to say in my 5 minutes, that they get a question that kind of throws them off, and they kind of want to bat the question away and get
They're
to
gone. Yeah.
arguments as soon as possible.
Yeah.
Uh, but I think, I kind of think a question from the court is actually the best opportunity that you have to persuade the court in 5 minutes, because you really can't do anything you haven't done already in your factum in 5 minutes. All you can do is, um, very
Okay.
clearly kind of give a sort of high level of,
Yeah.
here's, one or two things that we really care about, and here's why. Um, I think, the interventions that are sometimes the most successful is when I see counsel kind of picking up on maybe a question that the court has been grappling with, that they either haven't got a very satisfying answer to from the parties, or like maybe the answers have been fine, but the counsel wants to make sure that they consider it from the perspective of their client, and maybe from their client's perspective, there's something important that hasn't been said, in response to that question that needs to be said. I think that can be one way that 5 minutes can be used very effectively.
And Carter, can an intervener actually, or the argument that an intervener makes, can it actually change the outcome? Does it have any impact, or is it just an opportunity to have someone's voice heard, or does that argument actually change anything to the final, like, does it have an impact on the final decision? Do judges really take that into account when they want to make a decision, or it's just like, oh, it's good to know? Like, what is the approach, or what is the impact of an intervener's argument?
Sometimes they do. Yeah, I mean, certainly sometimes you see them in the reasons for judgment refer to points that have been made by interveners. I think, the court is particularly interested in hearing from interveners who either, represent groups that are going to be particularly impacted by a decision. Or, I think they're often very interested in when they have they have an issue that has to do with, um, how council can conduct cases. I think they're often very interested to hear from organizations like the CLA. Um, so yeah, I mean, I think that sometimes interveners can really have an impact on how the court views the issue before it.
Okay, so they have their like there is a utility to having an intervener in a case. It's not just to serve the organization and to help advance the voice of a certain group, but it also can actually help the argument, the main argument that's being um, displayed before the court, right?
For sure, yeah.
And I also wanted to ask Carter, because at the level when we do have an intervener, it's usually at the Supreme Court that we see a lot of interventions happening. Obviously, there's no evidence here at that point, right? It's only arguments. But what if someone wanted to bring some evidence? Is that possible as an
So
intervener?
interveners are not allowed to bring evidence. They're not allowed to introduce kind of new things the court has to do, like engage in, in fact finding and the assessment of evidence. They're not supposed to kind of distract the court from its main task of deciding the issue before the parties. Um, but yeah, I think of it as like the interveners are there really to, they all have their interests they want to advance, but they're there to assist the court in deciding the issue rather than to kind of give them a whole other thing that they have to do.
Right. And obviously, I mean, this is distinguishable from the concept of amicus, right? Because amicus is more like helping the court, but also helping a side more than actually bringing a group on to the.
Right. Right, right. When you're intervening, you're still an advocate for, a client who has a particular interest in the development of the law and how the court kind of decides the issue before for future cases. Whereas when you're amicus, you're a pure, friend of the court. You're the court's lawyer, and you're there to, to provide the court with assistance. Although, we know following Kasai that
Yeah.
that amicus can also take an adversarial position on the facts
Yeah.
in the law. When that is of assistance to the court because that's a perspective that they're lacking. So, they can, in that sense, advance the interests of the accused, but that's seen as kind of like an incidental benefit. Like you're advancing the interests of the accused because it's helpful for the court to have that perspective in order to properly decide the issues. Um,
And Carter, because I mean, you've had the opportunity to do to intervene on a number of cases now. So if maybe you can tell us if you find this experience rewarding, is it fun? It's definitely challenging because of the time constraints. It's like all this work that you have to do it. It has to be condensed, whether it's the factum, it's also limited in the number of pages or the oral submissions. But I mean, why do you do this type of work?
it's very rewarding and fun. It's true the timelines are pretty intense. But there's sort of the stakes are lower in the sense that you don't have a client whose life is on the line. And it's I find it to be like a very creative process because there is as I said, a broader range of arguments that you can make when you're not wedded to a particular outcome in this case. You're not acting for somebody who's going to be directly affected by this particular litigation. Um, so it can be a very sort of creative process deciding what arguments you're going to make. And I find the collaboration very rewarding as well. I'm often working with a whole, at least one or possibly several co-counsel on interventions. And you're also kind of working with the other intervenor counsel and the appellant's counsel sometimes, kind of, working at the problem. And so that's kind of nice because most of the time when I go to the Court of Appeal, it's just me.
Yeah.
Uh, me and the Crown and an articling student and maybe another Crown on the other side. So so that's kind of nice. And it's uh, yeah, I do find it very rewarding.
And that's maybe something that we should stress here when it comes to these types of cases, especially Supreme Court cases, is that they really give us lawyers the opportunity to work together and to connect and to meet other lawyers, maybe from other jurisdictions and other provinces sometimes. So that's really
Yeah.
also a very interesting thing. I mean, that's definitely how I got to work with you on a case. It's because of this intervention work.
I know I kind of miss the old days where we would all go to Ottawa and we would
Yeah.
all like meet and have dinner before court. And now, it's intervening is much more accessible for organizations now. They don't have to pay for counsel to travel to Ottawa and it's pro bono work. So it is, it's much more economical when you can do it on Zoom. But yeah, definitely you miss some of the experience of going and being there. But I still find it's kind of an event, like even though we're all in our offices on our computers, it's like we're all watching the appeal, and
Yeah.
often we're discussing it during the appeal. And yeah, and each one is different, right? Like each case has very different issues, and also acting for different kinds of interveners is a different experience, because the task is kind of different. So it's very varied work as well.
Yes. But it is also a lot of fun. I mean, it was fun to work on the Bharwani case. That was a very interesting experience, and it is, as you said, like it's challenging. It's a different type of challenge, and it really allows counsel to be more creative in the way they think about their arguments and what arguments they want to structure. Because you have to, I mean, at the end of the day, you have to be able to bring something new to whatever the parties are arguing. So that's really nice. Well, I want to really thank you so much, Carter, for taking the time today to talk to us about interventions. We will be talking to you again soon about some other work that you're doing. You're always working on interesting cases, so maybe we'll talk soon also about one of your cases. I know you have some of these crazy cases, the complex cases, so it will be nice to have you again to talk about one of these cases in the future.
Yeah, I'd be happy to. Thanks for having me.
It's my pleasure.